first in the last lecture series for the class of 2015. We're happy that you came out here at lunch to join us. There'll be pizza in the back throughout, so if you want more, go and get more. The last lecture series gives HLS faculty the chance to give a lecture as if it were the last one that they would ever give. The last lecture series showcases the academic and personal interests and passions of some of HLS's most popular professors in an informal setting. The purpose of these lectures is to allow professors and students to encounter one another outside of the classroom. Lecturing professors have the opportunity to speak on topics that are significant and intriguing to them. Our last lecture series helps connect students with the central purpose of legal education, the encouragement of intellectual curiosity. Professor John Coates IV joined the faculty in 1997 after private practice at New York law firm of Wachtell, Lipton, Rosen, and Katz, where he was a partner specializing in mergers and acquisitions. Currently, he teaches at the HBS campus. He teaches corporate governance and finance, and at HLS, he teaches M&A and corporations. He's also known for his Title IX work here at the campus, which we're all grateful for. So, without any further ado, I'll pass it off to Professor John Coates.
Thank you very much for that kind introduction, and thank you all for coming out. I'm honored. I got to impress my 10-year-old daughter with the fact that I was invited to give a class that you didn't actually have to go to. So I'm grateful for that. Anything I can do to impress her. And this is my last lecture, and my first lecture on the First Amendment, which I've never really covered before. So it's a bit of a venture for me, but I've been provoked enough in recent years to throw myself into learning something about con law, because no one who actually knows about con law knows anything about corporations, as far as I can tell. And nobody who studies and focuses on corporations knows much about the Constitution, so including me. It's interesting, and trying to bring together people from both sides of the faculty to focus on issues that are increasingly important in the Supreme Court and in public policy debates. And I'm going to talk today about some history, some data that I've analyzed, not terribly deep data analysis, but some basic stuff, and then some implications. And as you'll see, I'm fairly critical of where the law is drifting right now on this general topic. But I have an open mind about different approaches, and I'd be interested if people in the Q&A have their own views to add, not just ask me questions, but tell me what you think. And I'll try to keep this reasonably brief so we have a little bit of time left over for conversation. So here is I always like quizzes. I like quizzes. For any of you who've been my students, you know, if I had clickers, I would hand out the clickers and make you do this anonymously. Anybody want to take a stab? When did the Supreme Court first strike down a law under the First Amendment? And I didn't know this, by the way, until I looked it up. And even then, I'm not entirely sure until I've checked it with Larry Tribe and other people to make sure that what I found is actually right. Anybody want to guess? Even if you know absolutely no con law history, you can probably figure out from the structure of the question what the answer is. Right? It wouldn't really be interesting if it were, 1871, right? What's the answer? Nobody willing to guess. Come on, guys. It's like there's no grade hanging on it. What is it? 1931, exactly. That's the least intuitive answer, and that's the right answer. Anybody know that? Anybody know? Right? So for the first, count them up. 1931 minus 1789, however many years the Supreme Court had no role in enforcing the First Amendment in law. It was there. It was a statement of principle. It presumably influenced people from time to time to be reminded that it was in the Bill of Rights and not simply an important value, but it really had no legal role whatsoever. Okay, so here's another slightly different question. When did the Supreme Court first strike down a law at the request of a business under the First Amendment? Okay, so it has to be after 1931, or it could be 1931, I guess. I've already given away that that's wrong. Now, anybody want to take a guess at that one? You have to know how my mind works to guess. Anybody? So it's not 1957. That would be too easy because the last one was the latest date, so it's 1952. Okay, so now keep that in your mind. So no business was able to convince, even tried much, and didn't convince the Supreme Court to strike down any laws or regulations until 1952 under the First Amendment. Okay, and then last, finally, when did the Supreme Court first strike down a law at the request of a non-expressive business, right? So this 1952 case, again, I'll give it away, wasn't it. It was at the request of basically a book publisher. And then there were other cases in the 50s and 60s involving film companies and television companies that were all going after regulations that actually blocked them from doing the core business for which they've been authorized to function, which essentially often, obscene publications and the like, borderline. Publishing books that were viewed as treasonous, that kind of thing. But if you move outside the expressive industries now to manufacturing and service businesses and the rest of the entire economy that isn't about communication as what they're actually selling, the answer is 1978. So now I hate to ask, I'm almost embarrassed. How many of you were born after 1978? Wow, okay. All right, so most of your lifetime it has been going on, but for my lifetime, mostly it's pre the invention of this part of the First Amendment, right? The use of the First Amendment to strike down regulations for companies that are not in the business of talking for making money, but do so in various ways as an incident to doing their business. Usually this is in the form of advertising, marketing. That's where the biggest number of cases have come up, but it also has increasingly spilled into any activity that involves either affirmative statements, disclosures, or silence by companies. When they're forced to speak, they also now sue increasingly under the First Amendment because forced speech, of course, in the right context could be just as intrusive to First Amendment values as being forbidden to speak. So anywhere you've got disclosure as a component of regulation, it's now part of the First Amendment jurisprudence. There's at least a chance that the Supreme Court will strike down that regulation. Now, to a person coming out of the corporate world, this is all very peculiar. We tend to think, we're framed, when you take corporate law and securities law, we kind of get across the idea that the US approach to business regulation largely is about disclosure. And that's a good thing, because it leaves you free to do things as long as you warn people and inform them and bring everybody up to a level playing field on information. Then the principles of economics tell us that subsequent trades are usually going to be good things for the world. But it's conditioned on there being adequate information on both sides. Otherwise, there's a risk of fraud and deception and taking advantage and trades that are not, in fact, good for society. So disclosure is both viewed as a good thing in the world that I know, and it's certainly not as bad at interfering with economic activity as many other forms of regulation, which would have nothing to do with the First Amendment, right? That don't, if you just ban an activity, like you can't make a chemical as part of your activity, then the First Amendment doesn't really, there's no hook. But if you force the chemical company to tell people in the neighborhood, for example, that the chemical exposes them to a risk, then suddenly the First Amendment is now involved. This seems exactly backwards to me. My instincts are we shouldn't put a heavier hand on disclosure as a mode of regulation than we should on activity regulation, and yet, in a way, that's where we're ending up, just to forecast where I'm going in this talk. So to recap, 1931, 1952, 1978. These are the cases in case anybody is deeply interested in this. You can scribble them down quickly, and if you, eventually I'll have a paper published on this. Stromberg, Burston, and Virginia Pharmacy. Okay? Now, let's switch gears. When was the corporate form at the center of US economic growth? Well, basically the answer is the entire period. Because if you go back to the founding era, banks were crucial to economic growth. At the time, they're all formed as corporations. Okay? And then all the way down, all the way through the period that the US took over the world, which was around 1900. All right, you can see, maybe, in this chart, the US is here. that bar, and you can see around 1900 it's bigger than all the other bars. And it still is, by a little bit, bigger than China, but it certainly was all throughout the 20th century. So by 1900, now let me remind you, 1900, pre or post dates the first time the Supreme Court used the First Amendment to strike down any law whatsoever. Predates, there we go, excellent, he's paying attention. And 50 years before it's used one to strike down any business regulation, and 78 years before it was done in the current mode, okay? So what's the point of that? Well, the obvious point is the First Amendment didn't play any role in the economic growth that made the US the world's biggest economic power, okay? It was unimportant. It didn't play a role, except as background part of our overall commitment to liberties. Okay. Now, when did corporate speech get regulated? Well, again, the answer is the whole time. If you think about what contract law was, when you took contract law, the whole course is about speech. It's either written or verbal speech or silence. You may remember vaguely this case decided by Oliver Wendell Holmes in which buggy whips were involved, and then there's a case involving eels and all these weird fact patterns that no longer, the cow, all of this, the barren cow, all those cases are about silence or some form of communication. Did it form a contract or not? And economic penalties flow from when you speak and how you speak under various circumstances, okay? So speech has always been regulated in the commercial area. Now, we don't tend to think about the common law of contracts as a form of regulation, but it's essentially the same thing. And most consumer regulation today is modeled on various doctrines that were in place at the time of the founding. There are very few consumer regulations that are dramatically different than the combination of tort law and contract law that was in place in 1790, okay? So speech regulation has been around from the beginning. And then when you add layers as you move through history, antitrust law was there, corporate law was there, charter limits. At the time of the founding, almost all companies were established for very, very narrow purposes, which had to be set out in the charter. You had to get a charter from the state legislature or from Congress, and the price of it was both you had to give money, typically you had to bribe the people to get it. That was a good old-fashioned part of American corporate history, corruption. And you had to set out exactly what it was you wanted to do. And the reason for that was because they were very jealously guarded monopolies. They didn't want, if you got a charter, you didn't want him getting one to go in the same business, right? So you were dividing up the economy at the time through the corporate charters. So this was, in essence, again, very strict regulation on speech in a way, because if you got a bank charter, you couldn't go into the business of publishing newspapers. It was illegal. It was ultra-virus. So again, straightforward ban on expressive behavior through the corporate form because of corporate law from the beginning. So here's a reflection of this. This is the first articulation of any way that the Supreme Court thought about what a corporation was for legal purposes. Marshall, who was around, right? I mean, he actually was there when the Bill of Rights was written. And he was the first Chief Justice, and here's his view in 1819. Corporation is an artificial being possessing only properties which the charter confers on it. Okay? So it's, by definition, a product of regulation. The idea that it would have independent rights against the very government that creates it would never, I don't think, have occurred to him. And then if you go forward all the way up to, remember, 1978, which is when the Supreme Court really got in the business of applying First Amendment to corporate speech, layer on the Sherman Act, the Tillman Act, which still, so far, is hanging on by a thread as constitutional, banning corporations from giving money to politicians directly. Citizens United lets them spend money on independent expenditures. They have to buy their own ads, and they're in principle not supposed to coordinate with the candidate, although everybody knows that's kind of a fiction. But at least they can't give directly a lot of money to whomever, Romney, Obama, Clinton. They're all out there coordinating. But anyway, state blue sky laws, professional licensing laws, all kinds of laws. Essentially, if you think about what the professional license that you're going to get soon, many of you in the room, to be a lawyer is all about, you're going to get a license to speak as a lawyer giving advice. You're currently not allowed to do that. So When your cousins ask you for advice about their wills, say, I'm not allowed to tell you right now, right? I mean, and then even after you become a lawyer, you still might not want to tell them because they'll be mad at you when the advice turns out to be bad. Even if it was well-intentioned advice, right? Resist the urge to help your Aunt Matilda about her lease, all right? Just because it's no upside in that. Okay. Form of speech regulation. Truth in lending laws, securities laws, consumer, all this is in place long before we got to the first. So what, right? So obviously, if you're a strong originalist, this ought to matter to you. The First Amendment only means what the founders thought in a strong originalist version of interpreting the Constitution. And since everything I've just said to you would lead me to believe that the founders never would have occurred to them to think that corporations have First Amendment rights, that ought to be the end of the story. Of course, it's not for the notionally originalist Supreme Court members, because that doesn't suit their current policy purposes, in my opinion. But nevertheless, you could use this as an argument in a brief that might go somewhere. Less powerful versions of originalism affect most people. It's hard to imagine not at least reflecting a little bit on what the words of the Constitution were originally meant, even if all you're doing is Dworkinian, interpretivist, coming up with some kind of socially constructed meaning. It still ought to matter what was thought back then. And again, until 1978, no one really thought the First Amendment had much of a role in striking down business regulation. And then finally, just to reiterate, it's really not at all important that the First Amendment protect corporations for economic growth. In fact, I'm going to argue in a couple minutes just the contrary, but in any event, there's no affirmative virtue that you can demonstrate from history. Now, in principle, it is possible to imagine that had the First Amendment been enforced more strictly starting in 1801 against corporate speech, maybe we'd be even richer today than we are. Nevertheless, that counterfactual is a pretty heavy burden to bear given the incredible growth that we experienced as an economy up until 1900. So here's what's now going on. This is the number of businesses involved in First Amendment cases in the Supreme Court, and it was hovering around the 20% level. This is a moving 5-year average in the starting after the first ones in the 50s. And then you notice this big jump. Anybody want to take a guess what these two lines bracketing the jump represent? Yep. Interesting. It is roughly, I guess that's right. It does happen to coincide. But no, it's just coincidence that we get these two landmarks in abortion law. Any other guesses? What else happened in 1972 that ended in 1987? The only corporate lawyer to serve on the Supreme Court. Who's that? Lewis Powell. That's Powell's tenure on the court. He was a Richmond-based corporate lawyer who worked mostly for tobacco companies initially in his career, and then eventually rose up, worked for all kinds of big companies, served as a special counsel to Nixon, and then was put on the bench in '72. And unlike the litigator types like Roberts and other former lawyers for business, he actually knows something about business. The litigators mostly don't, right? I mean, they go in and they litigate. They don't really know about the businesses that they represent, except insofar as a case requires them to, but they don't have a general vision of what the business industry and so on might benefit from as a matter of profit. Powell had that vision. He knew exactly what would benefit companies. And he famously wrote a memo to the Chamber of Commerce in 1972 called the Powell Memo, which you can go find online. And it's an eye-opening memo because basically he lays out in about 15 pages the plan that has come to fruition over the last 30, 40 years. Business Roundtable is part of it. Basically, he doesn't use the words, but basically creation of the Business Roundtable, pulling the Chamber to the right. Chamber was actually kind of a politically neutral organization in the late 60s, often supported Democratic interest, had lots of small business members that were quite influential, now increasingly not, now much more focused on trade interests. And more importantly, towards the end of the memo, he also attacks Nader, and it's a great memo. It's a very quick skim, and it's very well written and very persuasive. And he basically makes the pitch that business needed to stop being politically uninvolved. They need to throw themselves into politics to combat the crazy left-wing lunatics in academia and the clergy and media, all of whom were pulling the economy and the country to the left. It's starkly political. I mean, it's a political memo. But the most interesting thing is in it, given who he is and the fact that he was about to go on the Supreme Court, is his view of the role of the courts and all this, which is they are, in his view, the most important instrument for social and economic and political change in the country, which he's probably right on some level. But for a about to be Supreme Court justice to privately be telling a trade group, and this, by the way, did not come out until after he was on the bench. So it didn't come out in his confirmation hearings. It would have come out today. In the current environment, it would have found its way to the media, but it didn't back then because we didn't have the internet and email and all the ways that information leaks these days. So the Congress, the Senate, didn't know that he had set up this vision when they confirmed him, and he went on the bench. And I've just put up the contrast here between that vision and this vision, very different, both from Republican Supreme Court justices. All right, so that takes you, that basically is an explanation. I mean, Powell was incredibly good at convincing the other like-minded members of the court, including the left. By the way, Brennan and the left part of the Supreme Court were so committed to First Amendment values, mostly on behalf of dissidents and students and people, war protesters and the like, that they were perfectly happy to make a bargain with Powell to go along with him to expand First Amendment protection to business because they viewed it as mostly good from their perspective for protecting liberties for individuals. They trade votes with him and he'd go along with him. So nevertheless, over time, he progressively also persuaded everyone on the Supreme Court except for Rehnquist, not exactly a liberal. He, throughout his whole career, resisted everything I'm about to show you. And I happen to think he was right. I think Powell was wrong. But in any event, divide among the right on this question. So 78, Virginia Pharmacy, repudiates expressly overrules two prior Supreme Court cases. Just doesn't even dance around the head. These are wrong. Sorry, we misled you. Rule of law, what's that? Let's just move along. Protected speech, it repudiated language even from a 1964 case, the famous Sullivan case, establishing First Amendment kind of in people's minds really in a strong way for the first time. In that case, the court had said, no, the speech here is not purely commercial. Had it been purely commercial, the court implied, it would have come out the other way. But because it was political, then it got protection. Virginia Pharmacy says, well, no more. Even if the speech in question is purely commercial and serves no identifiable political expressive goal, even if the individual involved has no real personal identification with the speech, any speech is speech. First Amendment doesn't distinguish on its face, and therefore we're going to extend protection to to commercial speech. And in particular, what it did, because this is a repeat pattern just to get a sense of the case law here, there was a regulation in place that made advertising drug prices hard in Virginia. It wasn't impossible, but it was much more difficult to advertise that you were the low-cost drug provider. And you'd think pharmacies would want then the ability to advertise in this way, but they were not the plaintiffs here. It was the consumer groups who wanted the price information in order to get lower drug prices, right? And so the court articulated the right to hear. Now that's a nice idea, and I get the intuition behind it. Of course, it drifts you away from the text of the First Amendment, which is about speech and not about the right to hear. Not at all clear whether standing was appropriately granted in that case. The court spends most of its time worrying about the standing issue, but finally convinces itself the consumer groups have standing to represent the interests of the speakers, and then the court finds that this drug information is properly speakable, despite the local law preventing it. And I might ask, why did they prevent drug advertising? And the answer basically is in a lot of difficult to evaluate product and service industries, speech regulation, advertising regulation has long been thought to be an important tool for combating fraud. If you regulate the way in which the services, or in this case drugs, are marketed, you can prevent certain kinds of overreaching by the sellers. It comes at a cost, which is reduced competition. And that's a trade-off. And my instincts often would be no regulation is better. But I also tend to think that the right body to be making that trade-off is not the court. It's an agency or a legislature, but not the court. And now the court is stepping in to reverse a policy trade-off between consumer protection on the one hand and price competition on the other, under the guise of First Amendment values, which to me don't appear really anywhere here in my view. This is about regulation of economic activity. This is not about speech in any way that the founders would have understood it. Okay, since Virginia Pharmacy, businesses went from having about a 20% win rate in First Amendment cases to almost exactly the same as individuals. They win about a little more than half the time in these cases in the Supreme Court. So fairly dramatic effect on case law. 1980, the Supreme Court formalized the Virginia Pharmacy approach with some very specific things. And in particular, I'll just flag the last one on the first three bullets there. Any regulation of commercial speech, as long as the speech is not deceptive, a big exception, by the way, because you're allowed to be deceptively political in your speech. There's no way a state could prohibit a political candidate from exaggerating the truth about his opponent. That would be clearly a First Amendment violation. Commercial speech, on the other hand, deception is not something that's legitimately expressible by commerce, even under the current Supreme Court doctrine. But if you move outside of deception and just get into truthful statements, then the court says the regulation has to fit, meaning it has to be no more restrictive than necessary. Now, this sounds nice, and it tracks prior First Amendment case law, for those of you who've had con law, the idea of fitting the constitutional doctrine to the requirements, but it's got a big problem. And the big problem is this is not how regulation and law is passed in this country. There is no it making the regulation. There is no single purpose typically involved. Usually there's some kind of very difficult political compromise to produce laws and regulations. And so you're almost loading the dice, not every time, but a lot of the time, that any court who wants to find a mismatch between the regulation and the purpose will be able to find one. It's inviting courts interested in deregulation, or actually more appropriately re-regulation of a given industry, to re-regulate using the First Amendment to do so, and doing it by simply saying, look, you didn't actually have to do it that way. You could have done it this slightly less intrusive way. And since the legislatures and regulators have to bargain with each other in order to pass anything, it's almost always going to be the case that you can find a gap between the articulated set of purposes. It's also interesting that the part of the court that does not like using legislative history in interpreting anything does so on the same ground that I'm articulating, but they don't seem to see the connection to their interpretation of the First Amendment here, right? They argue you shouldn't look at legislative history because Congress is a whole bunch of people, and legislative history is just what any individual thinks, not what the final compromise is all about. But they forget that wisdom when it comes to thinking about regulation under the First Amendment. Here's what's happened as a result of Central Hudson. This is cites to Central Hudson, and you can see a nice crude linear line there. It's not perfect, there's up and down, but nevertheless the overall trend is up. So basically 0.2 or 3 cases citing the Central Hudson at the courts of appeals every year more than the prior year over this whole period. And kind of this whole period is much heavier than this period. So increased levels of appellate court activity in commercial speech cases, generally striking down regulation, or at least trimming them. Okay, just to give you one sense of a current, very recent case to kind of give you a sense of what's at stake. Anybody like pomegranate juice? Palm sells it. Palm sells it by claiming that it will reduce your cholesterol, it will save you from prostate cancer, and it will improve your heart. And how do they know that? Because they have one randomly controlled trial study showing it. The FTC, based on FDA regulations, which they borrowed, said, we really want you to have 2 if you want to make unqualified claims. You can still make the claims, but you have to say preliminary research or initial research if you want to base it on 1. Does anybody think that's just a crazy regulatory idea? that if you're going to turn a marketing department on an incredibly profitable company loose on the public, your cousins, your aunts, your uncles, whomever it is that's the least savvy among your relatives, if you're going to turn that marketing department loose on them, you ought to have at least 2 studies before you drop the qualifier preliminary research and just say scientific research shows, which is now what they say. I don't know. To me that seems like a pretty sensible regulation, but apparently it violates the First Amendment, according to the DC Circuit. Why? Because it wasn't necessary to require 2 to establish the truth, according to the DC Circuit panel, who knows apparently nothing about science. Because if you want, go to scientific replication websites that collect examples of peer-reviewed published journal articles in the Journal of Public Health and the Journal of American Medical Association that are completely retracted, on average about 1 out of every 7. Let that one sink in for a minute. 1 out of every 7 drug-related studies published in peer-reviewed journals are eventually either retracted or substantially modified, right? So why do you need 2? You just need 1, according to the DC Circuit. So the regulation falls, and you can go back and rewrite the regulation if you want to be more limited in your approach. Do I sound slightly annoyed? I think this is just completely outrageous. I mean, another one that is apparently permitted by the First Amendment is you're allowed to market legal services to people who have been subject to some kind of event, saying you might be entitled to up to $40,000. Call us now. Which of course is totally deceptive, because up to $40,000 also means 0. That's up to $40,000, right? And yet they've done marketing studies on this, when you say that up to $40,000, most people either think it means 40,000, or maybe if they're really savvy, they do the average, which is 20. Even if the distribution of likely outcomes of these claims is like mostly 0, but occasionally somebody's got 100,000, right? So, but that's apparently First Amendment permitted. You're allowed to make that kind of a claim. So we now have the courts involved basically in writing the details of disclosure regulation across a whole range of industries, all because of Lewis Powell. And since 1978, an activist Supreme Court throwing itself into the business arena. This is not a good thing. It also is bad, not simply on direct regulatory grounds, but because it completely ignores the ownership structure of corporations, something close to my heart. It ignores the fact that most of these companies are not actually acting on behalf of their shareholders necessarily most of the time. Sometimes they are, sometimes they're not. But if you've taken corporate law, the people who run the company are the board, exactly, right? 12 people, most important rule of corporate law. The board decides, not the shareholders. So the board is 12 people. And in fact, they're only part-time. They only know what the management tells them. So in this kind of an issue, it's really just the senior management, who may or may not have the interest of the shareholders or the employees or anybody else associated with the corporation at heart. They might have their own particular interest. Their stock options might vest if they can get a pop in the stock price over the next 3 months. They'll retire, and who cares about the rest? That's not always true, but that's sometimes true, and therefore corporate governance does not typically always leave to the board everything. There are checks on the board, and the most important rule is the board decides, but we have numerous checks on what the board can and can't do, none of which is reflected in these decisions. So the court never distinguishes between whether a company involved is public or private. Okay? So to sum up, and I'll end here, let's flip it around. I've essentially denied the benefits of this doctrine. I now want to suggest there are real costs. And the costs are, first, just legal cost. This is a modern activist invention. It's not consistent with, at least I think, most natural understandings of the rule of law, which require regular process and publicity and uniformity and deliberation before we so massively change our approach to a fundamental constitutional question, right? Then, shifting to economics, it ignores difficult policy trade-offs, right? These costly transfers between consumers to producers, or maybe from companies to individuals or vice versa. These are really difficult, and it just sort of abstracts from those. And it's letting the court then change regulation without any analysis on the merits. It ignores corporate governance. It ignores socially costly transfers from shareholders to officers. And worse than just sort of ignoring those things, it actually creates an incentive for people running companies to make money not by improving the quality of their pomegranate juice, make it taste better, or improving their delivery, or lowering costs, all conventionally wonderful economic activities, but instead to hire really good lawyers, or at least ones related to a Supreme Court justice, like Eugene Scalia, and get him on your team, and then set up a nice made-up litigation that will eventually find its way to the DC Circuit to strike down the regulation, right? Is this how we want business to function? Do we want to reward rent-seeking? Do we want to reward what is inevitably going to be, on average, over time, nothing other than transfers, right? This is just transfers one population to another on average. It might be on any one case, this is a good decision actually for social welfare, but overall, you're just inviting more money to flow, nothing against you guys, but to lawyers, right? Which is not generally thought to be the way we want to spend our money. If anything, we want in business to minimize the amount of change over time, to create stability so you can predicate investments on it, and not have law depend on the lottery of which DC Circuit judges you get. Because currently, of course, you've got half Republican roughly and half Democrat, half pro-regulatory, half deregulatory, or depending on your cynicism, half maybe in favor of one particular set of industry groups and another in favor of another set of industry groups. And then depending on which panel of three you draw, that's going to tell you what the law is, right? So this is not a stable form, I don't think, for economic regulation. It might make sense where there are really, really difficult political trade-offs to be made and where minorities, meaning individual subsets of the population who need constitutional protection, need the courts there to check the legislature. Business doesn't need that. Business completely can play the lobbying and legislative game as well as any subgroup in America. So the idea they also need the courts jumping in to help them, just on its face, doesn't do it for me. And it adds to the rent-seeking, the costly rent-seeking cost, the drag on the economy that comes from that way of setting things up. It is an exaggeration, but I will say, to end, that that's Russia, right? That's a road to Russia. That's a road to living in an economy whose principal value is produced by transferring money over their resources, oil, here, law, fighting over with each other as opposed to engaging in innovation and in expanding production. I'll stop there. Okay? Questions, disagreements? Tell me why I'm wrong. Because this is the first time I've presented this stuff. Yeah, jump in.
I'm curious if you've seen or done any research just about the implications that sort of this turn in the First Amendment has had on businesses now trying other substantive constitutional protections, trying their luck there. Whether you think that if sort of the First Amendment keeps going that way, they're going to be trying their luck elsewhere.
I mean, the obvious answer to you is Hobby Lobby, which was a religious exemption, created by the Supreme Court for healthcare. They didn't. The owners and founders of the two companies in that case didn't. They don't want to be forced, in their view, to subsidize abortion, right, and certain kinds of birth control. And the court, now in fairness to Alito, who wrote the majority of opinion, he at least woke up to the ownership problem that Citizens United completely suppressed. He at least says, I'm not entirely sure whether this case should extend to publicly owned companies and other ownership patterns. And here I emphasize over and over again that all the shareholders were founding family members. They're all in agreement. They don't like this. There's no dissension. So we don't have to worry about the internal governance issues. So maybe the court is waking up to the second of the two problems I flagged, which is corporate governance. But there was a very healthy political debate over healthcare. It wasn't like it didn't get focused on. Congress spent an enormous amount of time wrestling with it. It did pass both houses with the requisite supermajority in the Senate It went to the Supreme Court on a straightforward challenge under the constitutionality, the more traditional, this is beyond the power of Congress to do. And despite all that, we still have essentially some companies rewriting the regulation to suit them based on religion. I think that's a bad sign. I think it's going to encourage more creative, if I can coin a phrase, constitutional entrepreneurialism. Right? We're going to be entrepreneurial now about the Constitution as applied to our business. I just want to emphasize, for any one company, it might be a good outcome. It might be, it'll make everyone happier in that family. Maybe the people who are losing out by the result of the case will find health care in some other way. Maybe this is actually good for society. But on average over time, I'm thinking not. I'm thinking it's a bad thing. And yes, so if you're going into practice and you want to join this rent-seeking society, if you want a to-do list, I'd get out the Bill of Rights and just start thinking about which ones might work for your company, because that may be, unfortunately, part of the future. Not just the First Amendment, but the Second Amendment, that would be interesting. Gun companies can fight tort law on the ground that the Second Amendment somehow, not sure how exactly, that takes some work. Good legal research. Other comments, observations? Yes?
Talk about this being essentially rent-seeking and funneling money to lawyers. But I sort of see this current securities law system to some extent in the same way, in that, it obviously has, there are reasons that it's in place and there were reasons before.
Mm-hmm.
But it does seem to impose large amounts of cost and does seem to funnel a huge amount of money into corporate law firms. So I'm wondering if you could consider or address the issue of the costs of these regulations.
Yeah, it's a fair point. You could certainly, and people have, right? Economists have for 20 or 30 years generally critiqued the American legal system precisely on this ground for encouraging litigation as a way of resolving social disputes, and that there are less costly ways to resolve these same kinds of disputes rather than through court. I think that's right. I think the difference to me here, though, is, remember, when you're talking about a constitutional resolution, the only way to change it is actually, three ways, right? One is somebody on the court dies, and then maybe they flip the balance of power through the nomination process. Second, you can pass a constitutional amendment in one of two ways, neither of which seems to be feasible anymore. Maybe, but at the very outermost margin. And so, unlike the securities law context, where at least in principle, if things got really, really bad, occasionally Congress does intervene in the PSLRA, and there have been amendments to the securities laws to reduce or mitigate some of the costs. Here, there's nothing Congress can do. Right? The only thing that we can do is pursue one of those two very difficult amendment processes, or just hope that they all get sick on the Supreme Court all at once, or at least some more than one. Right? It'd take more than one. Kennedy's the oldest. Ginsburg's ailing. I track these things actually. There probably will be eventually online betting markets around when they'll die. That's free market and rent-seeking in operation. Other thoughts, comments? What am I missing? Why is this clearly? I really am genuinely interested to know why I'm not right. What's any originalists want to take a stab at coming back at me on this? Any textualists? First Amendment, by the way, is an amazing little test for you if you think you're a textualist. Just go read it. It doesn't say anything about the president. It just says Congress shall make no law, which implies the president could just sign an executive order tomorrow taking away all of your right to speak. Do we think that's actually constitutional? Probably not, but the text says nothing about it, so it must not actually be a textualist approach that leads you to where you end up, and if that's true, then you can't really be a textualist. Okay? Seriously, anyway, so as follow-up, if anybody thinks I've missed something, if there's something dramatically off, if I'm just leaving out some part of the picture, please let me know, because as I say, I'm going to be publishing this and don't want it to be silly. On the other hand, if I've convinced you, or at least even gotten you worried enough, go do something about it. Thank you.
Thank you.